Hello friends, welcome back to the series of lecture. This is the 76th lecture of the series of CRPC. In today's lecture, we would start with chapter 21A, that is plea bargaining. It is from 265A to 265L. In plea bargaining also the criminal kind of offenses are there. If an offense is less than or equal to 7 years, 7 साल से छोटा या 7 साल के बराबर punishable offense है कोई, in that case the plea bargaining can be done. अगर कोई offense 7 साल या 7 साल से कम punishable है, then in that the plea bargaining can be done. It is Melmath Committee recommendation in 2003. So that we would write it in detail. Mainly plea bargaining में क्या होता है? That I am the accused and you are the victim. Plea bargaining में भी mainly वैसे compromise लगता है, but इधर conviction होगा. Compounding में you are acquitted, but here there will be a conviction in plea bargaining, but the sentence will be minimal. अमेरिका में in America there is charge bargaining. यहाँ पर एक्यूज और विक्टिम आपस में बार्गेनिंग करके चार्ज बड़े ऑफेंस का छोटे ऑफेंस में कन्वर्ट कर लेते हैं. ग्रीवियस हर्ट को हर्ट में कन्वर्ट कर लेंगे. इंडिया में चार्ज बार्गेनिंग नहीं होता, इट इज सेंटेंस बार्गेनिंग. तो चार्ज इधर उसी ऑफेंस का हुआ, जैसे कि थेफ्ट इन ड्वेलिंग हाउस, तो चार्ज तो उसी का हुआ थेफ्ट इन ड्वेलिंग हाउस का. बट इफ द विक्टिम और द एक्यूज victim and accused enter into the compromise and the accused is agreed to pay the compensation to the victim, then the compromise will be filed into the court and the court in that case as per law will provide the minimal possible sentence. या तो accused को probation पे छोड़ देंगे और probation अगर नहीं लागू होगा उस केस में तो मान लो सेंटेंस दे रखा है तो जो मैक्सिमम सेंटेंस है उसका 1/4 या हाफ इतना सेंटेंस आपको मिलेगा. सो दैट इज प्रोवाइडेड हियर इन दिस सेक्शंस. सो दैट इज व्हाट about plea bargaining. Overview of plea bargaining, that is sentence minimization. चार्ज खत्म नहीं होगा, conviction भी होगा. You are convicted also, but you are provided a minimal sentence. So write down the introduction of plea bargaining. Plea bargaining is the process. Plea bargaining is the process of bargaining between the accused and the victim, wherein the accused offers to pay compensation to the victim and the victim agrees for that. In lieu of the compensation, the court either releases the accused on probation or minimizes his sentence. Chapter 21A, sections 265A to 265L deals with the plea bargaining. कई बार आपसे चैप्टर नंबर पूछ लेता है पीटी वगैरह में और सेक्शन फ्रॉम विच सेक्शन टू विच सेक्शन. इट वाज एडेड in CRPC with effect from 5th July 2006. It was added in CRPC with effect from 5th July 2006. कई बार डेट भी पूछ लेता है. In India and England, the rule of sentence bargaining applies. In India and England, the rule of sentence bargaining applies, whereas in USA, charge bargaining applies. In charge bargaining, the court reduces the charge upon the bargaining. That is, the court convicts the accused on a lesser charge. The 12th Law Commission, in 142nd report, had recommended plea bargaining in 1991 and had declared that an accused who remorseful about his act, जिसको पश्चाताप है अपने जिस accused को अपने कार्य के लिए, about his act, and he is willing to compensate the victim, वो रेडी है compensate करने के लिए victim को for his act, जो offense उसने किया, cannot be treated at par, उसको उस एक्ट के इक्वल नहीं, cannot be treated as at par, मतलब उसके इक्वल नहीं ट्रीट किया जाएगा, with an accused who is willing to defend the case at a considerable cost and time. उस accused के बराबर नहीं रखा जाएगा जो accused अपने केस को डिफेंड करना चाहता है at a considerable cost और टाइम के, मतलब पूरा टाइम ले रहा है अपने डिफेंस के लिए. So that accused who is ready, who is remorseful about his act and willing to compensate the victim, that cannot be treated at par with an accused who is willing to defend the case at a considerable cost and time. So there are two kind of accused. One accused is remorseful and ready to compensate, and the other is saying that no, I am not committed the offense and I want to contest the case. But then earlier accept that I have committed, and he is remorseful and ready to compensate. तो इन दोनों को आप बराबर ट्रीट नहीं कर सकते. The accused who is ready to compensate, his sentence can be minimized and he can be awarded a lesser sentence, and he will be paying the compensation to the victim. So as accused, such an accused willing to compensate is remorseful. He is remorseful and willing to compensate, so he shall be allowed to plea bargain, but obviously not in real sense. Only those offenses which are punishable with 7 years or less. Now right again, the 156th Law Commission report in 1996 had endorsed the 142nd report. However, the Supreme Court in Muralidhar Meghraj Loya, Murlidhar Meghraj Loya, Muralidhar Meghraj Loya versus State of Maharashtra, 1976 Supreme Court, and also Kasam Bhai Abdul Rahman Bhai Sheikh versus State of Gujarat, 1980 Supreme Court, had rejected the concept of plea bargaining. But later on, upon the Malimat Committee report 2003 upon reforms in criminal justice system, the concept of plea bargaining was added to the CRPC. Now let's see what are the benefits of plea bargaining. There are normal benefits. First one is delay in criminal justice system would be avoided. दूसरा, burden upon the court. Burden of litigation on the court can be avoided. Victim can obtain the compensation plus unnecessary wastage of time. And anxiety cost. There is something called anxiety cost. What is anxiety cost? एंजाइटी कॉस्ट इज दैट कॉस्ट जब आप किसी प्रोसीडिंग्स को कंडक्ट करते हो तो आपका मेंटल इन्वॉल्वमेंट होता है. दैट एंजाइटी इन द केस, द माइंड इन्वॉल्व इन द केस, दैट रिजल्ट्स इनटू मे बी बैड हेल्थ आल्सो, एंड दैट अफेक्ट योर माइंड हेल्थ, दैट occupies your mind, so that can also be avoided. So write down the benefits of plea bargaining are: it reduces the burden of court, it will benefit several under trial prisoners. Third one, it saves the time and the cost of litigation. Next, it saves the anxiety cost. Next, it reduces the congestion. In the courts as well as in the prisons. Next is, it helps the victim obtaining compensation from the accused. So this is the background of plea bargaining. What is the benefit of plea bargaining? What actually is plea bargaining in India, and how it is differ from the American rule of charge bargaining. Now let's see from 265A to 265L. Small points जो बीच में बताऊंगा. Write it, note down into the small. Take a page and write it, note down, or otherwise note it on the bare act, because there are no need of a special dictation because they are simple procedure. You have to read, study and understand as it. Not only here, there are several other places where I have not given special dictations, but given few examples which I have not asked you to write down. Those examples are also important. So everywhere you have to be ready with a pen and page. It will help you a lot. और जिन लोगों ने भी ये प्रोसीजर अब तक फॉलो नहीं किया था वो दोबारा देखें, पेन पेपर के साथ रेडी रहें, हर एक पॉइंट को नोट डाउन करें, तभी आपके कुछ समझ में आएगा बेहतर, and you would get ready for the exams by that only. because writing practice आपकी जब तक नहीं होगी, you could not get ready for the mains exam, and the classes also became boring without noting down or writing. Now let's see 265A. Application of the chapter. This chapter shall apply. This chapter shall apply in respect of an accused against whom. This chapter shall apply in respect of an accused against whom the report has been forwarded. The report has been forwarded by the officer in charge of the police station under section 173. The report has been forwarded by the officer in charge of the police station under section 173, alleging therein that an offence appears to have been committed by him other than an offence for which the punishment of death or of imprisonment for life or of imprisonment for a term exceeding 7 years has been provided under the law for the time being in force. So they are talking about a police officer in charge committing a police report. Police officer in charge committing a police report for what kind of offense other than dying, death, life or exceeding 7 years, means for offenses less than or equal to 7 years punishable. अगर किसी accused के ऊपर एक पुलिस रिपोर्ट लगाया गया है after investigation that he has committed such an offense, then their plea bargaining can be done. पुलिस रिपोर्ट के बाद भी आप कर सकते हो. There they are saying after a police report. पुलिस रिपोर्ट फाइल होने के बाद कभी भी आप plea bargaining कर सकते हो. Read it again. The report has been forwarded by the officer in charge of the police station under the section 173, alleging therein that an offence appears to have been committed by him other than an offence for which the punishment of death or imprisonment of life or imprisonment for a term exceeding 7 years has been provided under the law for the time being in force. अब यहाँ पे I just keep on telling you the discrepancies simultaneously because this is not the law which is much interpreted by the Supreme Court till now. So you have to just keep in mind the discrepancies. So यहाँ पर it is not very clear. They are saying that पुलिस रिपोर्ट फाइल होने के बाद ही accused plea bargaining कर सकता है या फिर issue of process के बाद करेगा. They are not very clear because in police case accused is in picture always. FIR उसके खिलाफ है, he may be arrested etc before filing the charge sheet. But ultimately after the police report, no one knows whether the magistrate take cognizance against the accused. Then what is the need of plea bargaining? After the filing the police report, magistrate may not take cognizance. Then what is the need of plea bargaining? So according to me, it is only when the magistrate decide to take cognizance, the accused will go for plea bargaining. In the police report case also, it is not immediately after the police report, rather thereafter when the magistrate decides to take cognizance, then he will go for plea bargaining. So write it down simultaneously. लिखते रहिए आप. Next clause, a magistrate has taken cognizance of an offence on complaint other than an offence for which the punishment of death or of punishment for life or of imprisonment for a term exceeding 7 years has been provided under the law for the time being in force, and after examining complainant and witnesses under section 200 issued the process under the section 204. अब यहाँ पर they are very clear. In complaint cases they are very clear. In complaint cases they are very clear that the offence should be less than or equal to 7 years. Plus, it is not only on the cognizance of complaint. It is only after the complaint proceedings. If the issue of process has been made, then only the accused can go for plea bargaining. जबकि 173 वाली रिपोर्ट में ये क्लियर नहीं किया है कि accused plea bargaining कब करेगा. रिपोर्ट फाइल होने के बाद करेगा या फिर cognizance लेने के बाद करेगा या फिर issue of process के बाद करेगा. तो उसमें तो बताया कि cognizance के बाद कर सकता है, मैंने बताया. But in complaint cases they are very clear that the plea bargaining can be done only after the issue of process is done. Only after the issue of process is done under section 204. अब इसमें एक discrepancy ये है कि they talked about the police report, they talked about the complaint, but they do not talked about the information. So that is one small discrepancy. जब पुलिस रिपोर्ट केस में और कंप्लेंट केस में प्ली बार्गेनिंग हो सकता है, then there is no reason why इंफॉर्मेशन केस में प्ली बार्गेनिंग नहीं हो सकता. अकॉर्डिंग टू मी इंफॉर्मेशन केसेस में भी after the issue of process has been done, plea bargaining should be allowed. In the information cases, after the issue of process, plea bargaining would be allowed if the offense is 7 years or less than punishable. तो information cases लिखा नहीं है, but obviously that has to be there. But does not apply where such offense affects the socio-economic condition of the country or has been committed against a woman or a child below the age of 14 years. इन केसेस में प्ली बार्गेनिंग नहीं होगा. एक तो बड़े वाले 7 साल से बड़े वाले ऑफेंस में प्ली बार्गेनिंग नहीं होगा. दूसरा, इट विल नॉट अप्लाई दोज ऑफेंसेस विच अफेक्ट द सोशो इकोनॉमिक कंडीशन, मीन्स दोज ऑफेंसेस विच आर सोशो इकोनॉमिक ऑफेंस, उनमें नहीं होगा. या फिर इट रिलेट्स टू ए वुमेन और इट रिलेट्स टू ए चाइल्ड बिलो 14 years. तो 4 केसेस में दे आर सेइंग the plea bargaining will not take place. One is offense greater than 7 years. 2 is offense against the woman. Third one is offense against the child. It include the male and female child, because woman तो किसी भी एज की हो सकती है, वो इंक्लूड कर ही रहा था, but obviously it is male child or other child, कोई भी child हो less than 14 years, or if it is a socio-economic offense. अब सोशो इकोनॉमिक ऑफेंस क्या होगा? दैट द गवर्नमेंट ऑफ इंडिया विल डिक्लेयर बाय द नोटिफिकेशन. एग्जाम्पल, डॉयरी प्रोहिबिशन एक्ट, फूड अडल्ट्रेशन एक्ट, फेमा, ये जितने भी हैं दैट आर कंसिडर्ड टू बी ए सोशो इकोनॉमिक ऑफेंसेस. नाउ सेकंड क्लॉज, फॉर द पर्पस ऑफ सेक्शन 1 द सेंट्रल गवर्नमेंट शैल बाय नोटिफिकेशन डिटरमाइन द ऑफेंसेस अंडर द लॉ for the time being in force which shall be the offense affecting the socio-economic condition of the country. So the central government by notification declare what offenses are the socio-economic offenses. So in these cases the offense punishable more than 7 years, the offense related to against the woman, the offenses against the child who is less than 14 years, and the socio-economic offenses. In these cases the plea bargaining would not apply. Information cases, complaint cases after the issue of process, and the police report case after the taken cognizance, the plea bargaining can be done. Now the next is plea bargaining का process क्या होगा? Now suppose A is the accused, अब उसके खिलाफ complaint case में issue of process हो गया है. Now this A wants to plea bargain. Now the question arose whether he would appear in the court or he appear with his lawyer, through his lawyer. So he can appear himself or through his lawyer, and he can file an application of plea bargaining. या तो वो खुद कर सकता है या फिर अपने वकील के थ्रू करवा सकता है. एप्लीकेशन फॉर प्ली बार्गेनिंग मतलब वो बताएगा कोर्ट को ये बताएगा कि मैं विक्टिम के साथ प्ली बार्गेनिंग करके कंप्रोमाइज करवाना चाहता हूँ, और साथ में एक एफिडेविट लगाएगा, एप्लीकेशन के साथ एक एफिडेविट लगाएगा कि मुझे ऑफेंस का नेचर पता है, किस तरह का सेंटेंस मिलेगा, ऑफेंस में किस तरह का सेंटेंस मिलेगा ये भी मुझे पता है. सो ऑल दीज थिंग्स ही वुड राइट and court will examine whether this is written voluntarily or not. So let's see. A person accused of an offense may file an application for plea bargaining in the court in which such offense is pending for trial. तो जिस कोर्ट में मैटर पेंडिंग है ट्रायल के लिए, उसी कोर्ट में आप एप्लीकेशन फॉर प्ली बार्गेनिंग लगाओगे. सेकंड क्लॉज, द एप्लीकेशन अंडर सबसेक्शन 1 shall contain a brief description of the case relating to which the application is filed, including the offense to which the case relates, and shall be accompanied by an affidavit shown by the accused stating therein he has voluntarily preferred, after understanding the nature and extent of punishment provided under the law for the offense, the plea bargaining in his case, and that he has not previously been convicted by a court in a case in which he had been charged with the same offense. पहले तो वो the accused would explain the case number वगैरह, FIR number, all these things he would tell, application में लिखेगा. फिर he would talk about the offense under which section talking about the offense, the case is pending. Then he will declare through an affidavit that I understand the nature of the offense and I understand the nature of punishment also, and that I am making an application of plea bargain voluntarily. Plus, in affidavit, it will also be declared that I am not previously convicted by any court of the same offense. ऐसा हो सकता है ना, पहले उसी ऑफेंस के लिए किसी कोर्ट में कन्विक्ट हो गया था और बाई चांस वही केस इस कोर्ट में दोबारा शुरू हो गया और प्ली बार्गेनिंग करना चाहता है, तो उसको डिक्लेयर करना पड़ेगा कि मैं इसी ऑफेंस में, ऐसा नहीं कि ऐसे ही किसी ऑफेंस में, इट इज नॉट रिटन सिमिलर ऑफेंस ऑफ सेम काइंड ऑफेंस, इट इज रिटन सेम ऑफेंस, उसी ऑफेंस में, सेम ऑफेंस में मैं कभी पहले कन्विक्ट किसी और कोर्ट में नहीं हुआ. इट इज नॉट अबाउट द सिमिलर ऑफेंस, इट इज ऑफ सेम ऑफेंस. So he has to give an undertaking in the affidavit. He has not previously been convicted by a court in a case in which he had been charged with the same offense. Clear लिखा हुआ है. In which he had been charged with the same offense. Same offense means अभी जिस एक्ट के लिए मेरा ट्रायल चल रहा है या प्रोसीडिंग्स चल रहा है उसी के लिए मैं कभी कहीं पे चार्ज नहीं हुआ, कन्विक्ट नहीं हुआ. So what all declaration he will make? Case का brief details. The offense he will state. Then he will state that he is making it voluntarily. Understand the nature. He also understand the nature of the offense and also the punishment to be given in that offense. And also give undertaking that he is not being punished previously for the same offense. So this is the application or affidavit that he will file. एप्लीकेशन के साथ एफिडेविट देगा. कोर्ट उसके बाद क्या करेगी? कोर्ट नोटिस देगी इस एप्लीकेशन का कंप्लेनेंट को. कंप्लेंट केस है तो कंप्लेनेंट को, और पुलिस केस है देन टू पब्लिक प्रोसिक्यूटर को. पुलिस केस है या इंफॉर्मेशन केस है तो पब्लिक प्रोसिक्यूटर को नोटिस करेगी. उसके बाद कोर्ट. कंप्लेंट केस है तो कंप्लेनेंट को नोटिस करेगी. उसके बाद डेट फिक्स होगा कि इतनी तारीख को हम अगली सुनवाई करेंगे. इस बीच में नोटिस जाएंगे जितनी भी पार्टीज हैं कंसर्न उनको. देन दे विल स्टार्ट नेगोशिएटिंग बिटवीन देमसेल्व्स अंडर द ब्रॉड सुपरविजन ऑफ द कोर्ट as to what compensation should be awarded. उसके बाद कोर्ट एक बार एग्जामिन भी करेगा एक्यूज को पर्सनली, whether the accused made it voluntarily or not. ये एप्लीकेशन आप लॉयर के थ्रू भी भेज सकते हैं, बट जो एग्जामिनेशन है कोर्ट पर्सनली करेगा ऑफ द एक्यूज को पर्सनली एग्जामिन करेगा. आफ्टर रिसीविंग द एप्लीकेशन अंडर सबसेक्शन 1, the court shall issue notice to the public prosecutor or the complainant of the case, as the case may be, and to the accused to appear on the date fixed for the case. So पुलिस केस में या इंफॉर्मेशन केस में नोटिस टू द पब्लिक प्रोसिक्यूटर और कंप्लेंट केस में नोटिस टू द कंप्लेनेंट एंड टू द accused to appear on the date fixed for the case, and then the court will fix a date on which they have to appear, and on that date the court will examine the accused whether he is making it voluntarily or not. So इन कैमरा एग्जामिनेशन होगा. ये जो एग्जामिनेशन हुआ कोर्ट के द्वारा, इन कैमरा मतलब विदाउट द पब्लिक. When the public prosecutor or the complainant of the case, as the case may be, and the accused appear on the date fixed under section 3, the court shall examine the accused in camera, where the other party in the case shall not be present, to satisfy itself that the accused has filed the application voluntarily. So first step after the application is fixed a date. On this date, the complainant, the public prosecutor, the accused, they will all appear, and the court will examine the accused in the absence of general public in camera. In camera का provision है section 327. Section 327 is the provision for in camera proceedings, and the proceedings will be in camera, and court will examine only as to whether the application is made voluntarily or not, to satisfy itself that the accused has filed the application voluntarily, and where the court is satisfied that the application has been filed by the accused voluntarily, it shall provide time to the public prosecutor or the complainant of the case, as the case may be, and the accused to work out a mutual satisfactory disposition of the case, which may include giving to the victim by the accused the compensation and the other expenses during the case, and thereafter fix the date for further hearing of the case. अगर कोर्ट को लगता है the court finds that it is voluntarily, then the court will give time to the public prosecutor, accused, everyone to enter into the mutual negotiations and arrive at a conclusion regarding the compensation. कितना compensation दोगे आप? ये सिर्फ compensation नहीं है, ये जो कोर्ट में खर्चे हुए हैं विक्टिम के, कोर्ट में जो खर्चे हुए हैं विक्टिम के, that will also be paid by the accused along with the compensation. अब how much of the compensation will, that would not the court decide, that the both accused and victim have to decide on their mutual negotiations. अब कोर्ट उसके बाद डेट फिक्स कर देगी that on so and so date I would examine that whether there is satisfactory disposition or not. And the meanwhile is the court finds that the application has been filed involuntarily by the accused, or he has previously been convicted by a court in a case in which he had been charged with the same offense. It shall proceed further in accordance with the provisions of this code from the stage such application has been filed under subsection 1. तब तक जब तक ये proceedings चलेंगे उनके meanwhile the court finds that the application has been filed involuntarily by the accused, or he has previously been convicted by the court in case in which he had been charged with the same offense. It shall proceed further in accordance with the provisions of this code from the stage which from the stage such application has been filed under subsection 1. Means what? The court will go for normal trial. So fourth step is what? Application के कंटेंट हम देख चुके हैं क्या थे. एप्लीकेशन के बाद कोर्ट विल फिक्स ए डेट ऑफ हियरिंग, और उसका नोटिस भी तो देगा कोर्ट टू द पीपी और द कंप्लेनेंट as the case may be. If it is a case of police report or information, notice to be given to the public prosecutor. If it is a case of complaint, then notice to the complainant. Now next, what after date of hearing? On the date of hearing, there is on the date of hearing there is in camera examination of the accused, and the purpose of in camera examination is only to find out as to whether application is moved voluntarily or not. If it is found to be voluntarily, then what? Then the court will fix a date and require the PP or the complainant and the accused to enter into a compromise. Require means direct them to enter into a compromise through negotiations. उसी को कहते हैं mutually satisfactory disposition. यहाँ पे बेसिकली कंपनसेशन पे डिसाइड करेंगे आपस में. अगर एग्री कर गए ठीक है, नहीं किया तो कोई बात नहीं, फिर तो नॉर्मल ट्रायल तो चलेगा. एंड इफ इट इज फाउंड दैट इट इज नॉन वॉलंटरली, देन नॉर्मल ट्रायल. नॉर्मल ट्रायल मीन्स नॉर्मल इंक्वायरी, ऑल दैट नॉर्मल प्रोसीडिंग्स. और अगर म्यूचुअली एग्री भी नहीं हो पाते, नेगोशिएशन पे नहीं पहुंच पाते, तब भी नॉर्मल ट्रायल चलेगा. अब ये जो सेटिस्फैक्ट्री डिस्पोजिशन का जो प्रोसेस होगा, सेटिस्फैक्ट्री डिस्पोजिशन का प्रोसेस होगा, वो किस तरीके से होगा, दैट इज गिवन इन द नेक्स्ट सेक्शन. सो हाउ द negotiation satisfactory disposition takes place, this is given in this section. Let's see. In working out of a mutually satisfactory disposition, a mutual satisfactory disposition under clause A of subsection 4 of section 265B. In working out of mutual satisfactory disposition under clause A of subsection 4 of 265B, this satisfactory disposition, subsection 4 clause A of 265B. In working out a mutual satisfactory disposition under clause A of subsection 4 of section 265B, the court shall follow the following procedure. उसके बाद ये पुलिस रिपोर्ट की बात अलग कर रही हैं और कंप्लेंट केसेस की बात अलग कर रही हैं. In a case instituted on a police report, the court shall issue notice to a public prosecutor, the police officer, investigating officer, the accused and the victim. 4 लोगों को नोटिस जाएगा. If it is a case of police report, then 4 people will participate: the public prosecutor, the IO, the accused and the victim. If the case is of police report, then 4 people would participate: public prosecutor, IO, accused and the victim. they all will be served to notice and served by the notice. They all will serve by the notice, and they all will participate in the process of negotiations. Provided that throughout such process of working out of a satisfactory disposition of the case, provided that throughout such process of working out a satisfactory disposition of the case, it shall be the duty of the court to ensure that the entire process is completed voluntarily by the parties participating in the meeting. जब ये सुपरवाइजरी दे दिया कोर्ट को, कोर्ट ने डेट लगा दिया कि इतने तारीख को आपको अपियर होना है, इस बीच में आप अपना नेगोशिएशंस कर लो, और कोर्ट ने नोटिस सर्व कर दिए, फिर भी दे आर सेइंग अंडर द ब्रॉड सुपरविजन ऑफ द कोर्ट हैज टू एंश्योर दैट द एंटायर प्रोसेस इज completely completed voluntarily. That is, the court has to ensure that the process of negotiation is voluntarily. How the court ensure that? Because that meeting is not happening in front of the court. इसके लिए कोई हार्ड एंड फास्ट ज़्यादा रूल नहीं लिखा हुआ. सो फॉर दैट द कोर्ट हैज़ टू ड्राइव इट्स ओन मैकेनिज्म. या तो कोर्ट एक परमानेंट पैनल बना लेगा हर कोर्ट में, जैसे कि मीडिएशन पैनल होते हैं, उसी में से किसी एक को इस मीटिंग का हेड बना देगा, या फिर किसी सीनियर लॉयर को उसका हेड बना देगा, या फिर किसी मजिस्ट्रेट को डायरेक्ट कर देगा कि तुम्हारे सुपरविजन में होगा. सो अल्टीमेटली द कोर्ट हैज़ टू एंश्योर दैट हैज़ टू बी डन voluntarily. It is completed voluntarily. So the court may drive its own mechanism to ensure that the process is completed voluntarily. So write down a point here. The court has to ensure the voluntary character of the plea bargaining. The court has to ensure the voluntary character of the plea bargaining process, but nowhere it is provided that what should be that process. The court has to decide or drive its own mechanism. It may appoint some person to supervise the proceedings. It may appoint some person to supervise the proceedings. Provided further that the accused, if he so desires, may participate in such meeting with his pleader, if any engaged in the case. मतलब accused अपने lawyer के थ्रू भी participate कर सकता है. जो victim होगा, victim is also having support of his lawyer, so accused can also appear with his lawyer. So accused can also appear with his lawyer. कुत्ता नहीं पड़ेगा, but he can appear with his pleader also. अगर कंप्लेंट केस नहीं है तो विक्टिम तो पब्लिक प्रोसिक्यूटर द्वारा रिप्रेजेंटेड है, सो इस वजह से एक्यूज्ड भी अपने प्लीडर के साथ आ सकता है. अब यहाँ पर कोई आर्गुमेंट्स तो नहीं होंगे वैसे. सो इट इज़ टू बी एंश्योर्ड दैट अगर एक्यूज्ड के साथ कोई ज़बरदस्ती ना हो, और उसके लिए अगर एक्यूज्ड का लॉयर साथ में है, देन इट वुड बी एंश्योर्ड दैट द नेगोशिएशंस आर डन प्रॉपरली. ऐसा ना हो कि भाई विक्टिम बोलेगी मेरे को 10 लाख कंपनसेशन दे, सो एंड सो फोर्थ. सो दिस वाज द पुलिस रिपोर्ट केस. नाउ द नेक्स्ट वन इज इन केस इंस्टीट्यूटेड अदरवाइज देन ऑन ए पुलिस रिपोर्ट. अब यहाँ पर ये कंप्लेंट केस नहीं कह रहे. अदरवाइज देन पुलिस रिपोर्ट मीन्स इट कैन बी ए कंप्लेंट केस or it can be an information case. In a case instituted otherwise than on a police report, the court shall issue notice to the accused and the victim of the case to participate in a meeting to work out a satisfactory disposition of the case. अब यहाँ पर पब्लिक प्रोसिक्यूटर वगैरह को नोटिस नहीं जाएगा, लेकिन ध्यान रखिएगा अगर इन्फॉर्मेशन केस होगा तो वहाँ पर पब्लिक प्रोसिक्यूटर को भी नोटिस जाएगा. कंप्लेंट केस में नोटिस टू द accused and the victim, but in information cases notice also served to the public prosecutor. Provided that it shall be the duty of the court to ensure throughout such process of working out a satisfactory disposition of case that it is completed voluntarily by the parties participating in the meeting. So here is also the same thing. यहाँ पे भी वही होगा, supervision करना पड़ेगा. Provided further that if the victim of the case or the accused, as the case may be so desires, he may participate in such meeting with his pleader engaged in the case. अब यहाँ पर accused की तो बात कर ही रहे हैं, साथ में they are also talking about the victim. Victim also can appear through his lawyer and accused also can appear through his lawyer. लेकिन पुलिस रिपोर्ट केस में they do not talk about the victim. They only talk about the accused. Why? बिकॉज वहाँ पे पुलिस रिपोर्ट केस में विक्टिम को रिप्रेजेंट करने के लिए पब्लिक प्रोसिक्यूटर इज ऑलवेज देयर, बट इन कंप्लेंट केसेस पब्लिक प्रोसिक्यूटर मे नॉट बी देयर टू रिप्रेजेंट द कंप्लेनेंट विक्टिम देयरफॉर यहाँ पे उन्होंने विक्टिम भी लिखा है और एक्यूज्ड भी लिखा है. In the complaint cases, public prosecutor may not be representing the victim, and therefore they are talked about the victim as well as the accused. But in police report case, they are talking about only about the accused because victim is already represented by the public prosecutor. So here they are writing accused with his pleader as well as victim with his pleader. Now next, अभी report हो गया and they have entered into the satisfactory negotiations. Now they will submit this report to the court, where in a meeting under section 265C, a satisfactory disposition of the case has been worked out. The court shall prepare a report of such disposition, which shall be signed by the presiding officer of the court and all other persons who participated in the meeting, and if no such disposition has been worked out, the court shall record such observation and proceed further in accordance with the provisions of this code. From the stage, the application under subsection 1 of section 265B has been filed in such case. Means satisfactory disposition अगर नहीं हुआ then normal trial, और satisfactory disposition हो गया, the court will prepare a report of that, sign it himself, and get also signed by all the parties concerned, accused and victim, etc. अगर satisfactory disposition नहीं हो पाया तो normal trial चालू होगा. From the stage of application उधर से proceedings चालू हो जाएंगी, और अगर satisfactory disposition हो गया then what? Then next is quantum of sentence. What is the punishment the court gave if the satisfactory disposition held? Means सबसे पहले application के बाद notices plus date given by the court, next date. On that date, the examination to be done, whether it is voluntarily. Then on examination, if court find it is not voluntarily, then normal trial will take place. And if the court satisfy it is voluntarily, then further notice, then the supervision of the process of plea bargaining, that is satisfactory disposition. उसके बाद if no satisfactory disposition, then the normal trial will go on from the stage of the application. And if there is a satisfactory disposition, then comes the question of issue of sentence. What sentence to be given to the accused? कोर्ट हमेशा सबसे पहले ये एग्जामिन करेगा कि इस केस में प्रोबेशन तो नहीं दिया जा सकता. सेक्शन 360 ऑफ CRPC टॉक्स अबाउट प्रोबेशन, या फिर यू गेट द प्रोबेशन ऑफ द ऑफेंडर्स एक्ट. क्या एक्यूज को प्रोबेशन पे छोड़ा जा सकता है या फिर एडमोनिशन करके छोड़ा जा सकता है? अगर हाँ तो प्रोबेशन पे छोड़ सकती है कोर्ट. बट इफ द कोर्ट फाइंड्स दैट द प्रोबेशन इज नॉट एप्लीकेबल इन दिस केस, अगर कोर्ट को ये ज्ञात होता है कि इसमें प्रोबेशन नहीं लगेगा, then the court will go for the minimization of sentence. If the offense is declared minimum sentence, अगर offense कहता है कि this is the minimum sentence, then the court will award half of that minimum sentence. मान लो कोई offense है that is minimum punishable with 7 years, minimum punishment उसकी 7 year है, उससे कम नहीं दी जा सकती. वैसा ऐसा कोई एग्जाम्पल मिलेगा नहीं जिसमें मिनिमम 7 year है, तो फिर उसमें हायर ऑफेंस हाईएस्ट पनिशमेंट ज़्यादा होगी तो वो लाई नहीं करेगा उसमें. लेट्स सी अनदर एग्जांपल, कोई ऑफेंस है जिसकी मैक्सिमम पनिशमेंट 7 years है और मिनिमम पनिशमेंट उसकी मान लो 3 years है. द ऑफेंस इज पनिशेबल 3 to 7 years, मिनिमम 3 year एंड मैक्सिमम 7 year. तभी तो लगेगा ये, अगर वो वुमेन चाइल्ड एक्सेट्रा अदर उसमें ना आ रहा हो एक्सेप्शंस में. सबसे पहले तो कोर्ट प्रोबेशन वगैरह चेक करेगा, प्रोबेशन में छोड़ दिया तो बेस्ट, नहीं तो जो भी मिनिमम सेंटेंस प्रोवाइड है उस केस में, उस ऑफेंस में, उसका आधा. सपोज इन दैट केस नो मिनिमम सेंटेंस इज प्रोवाइडेड. सपोज इट इज डिक्लेयर्ड दैट द ऑफेंस इज पनिशेबल विद 3 years बट देयर इज नो मिनिमम सेंटेंस, देन व्हाट? देन व्हाटएवर इज द मैक्सिमम सेंटेंस, व्हाटएवर बी द मैक्सिमम पनिशमेंट, उसका 1/4 will be provided. So that is the approach of the court. Now let's see the next section 265E, where a satisfactory disposition of the case has been worked out under section 265D, the court shall dispose of the case in the following manner. Number 1A. The court shall award the compensation to the victim in accordance with the disposition under section 265D and hear the parties on the quantum of punishment. अब जो amount of compensation है वो तो मिल जाएगा victim को, that will be given to the victim, and then the quantum of punishment per year that will take place. Releasing of the accused on probation of good conduct or after admonition under section 360. Admonition मतलब डांट फटकार कर छोड़ना, बरसना. It would be on record warning, admonition. और probation में आप sentence तो अवॉर्ड करोगे but he will be out of jail. Releasing of the accused on probation of good conduct or after admonition under section 360 or for dealing with the accused under the provisions of the Probation of Offender Act 1958 or any other law for the time being in force and follow the procedure specified in the succeeding clauses for imposing the punishment on the accused. तो ये क्लाउज क्या कह रहा है? सबसे पहले तो आप कंपनसेशन अवार्ड करोगे विक्टिम को. After that you will conduct a hearing whether he is to be released on probation, admonition or any other sentence. Next clause, after hearing the parties under clause A. After hearing the parties under clause A, if the court is of the view that section 360 or the provisions of the Probation of the Offender Act or any other law for the time being in force are attracted in the case of the accused, it may release the accused on probation or provide the benefit of any such law as the case may be. Second clause is talking about release on probation. अगर probation पे छोड़ सकते हैं तो probation पे छोड़ दीजिए. अगर probation पे नहीं छोड़ सकोगे तब क्या? Then you will look out the quantum of sentence. After hearing the parties under clause B, if the court finds that the minimum punishment has been provided under the law for the offense committed by the accused, it may sentence the accused to half of such minimum sentence. अब मान लीजिए किसी ऑफेंस में लिखा 3 साल मिनिमम होना चाहिए, 7 साल मैक्सिमम और 3 साल मिनिमम. देन इन दैट केस 3 का आधा 1.5 years. In case after hearing the parties clause under clause B, the court finds that the offense committed by the accused is not covered under clause B or clause C, then it may sentence the accused on to one-fourth of the punishment provided or extendable as the case may be for such offense. कई बार क्या होता है किसी ऑफेंस में लिखा है punishment is 5 year extendable to 7 years, तो उसमें मैक्सिमम पनिशमेंट क्या मानोगे? 7 years. अगर एक्सटेंडेबल लिखा है तो जो भी एक्सटेंडेबल वाला पीरियड दैट इज द मैक्सिमम पनिशमेंट. देन उसका कितना? उसका 1/4. इधर मिनिमम नहीं दे रखा, 5 years एक्सटेंडेबल टू 7 year लिखा है तो इस वजह से 1/4 होगा. इसमें मिनिमम नहीं दे रखा इस एग्जांपल में. अगर मिनिमम सेंटेंस प्रोवाइडेड है, मिनिमम इतनी पनिशमेंट होगी और मैक्सिमम 7 years तक होगी तो उसका हाफ, और अगर मैक्सिमम पनिशमेंट दे रहा है तो उसका 1/4. दैट इज व्हाट is called the minimization of sentence on plea bargaining. Compensation victim को मिल गया and accused either released on probation or admonition or a minimum sentence is provided. अगर minimum sentence दे रखा किसी offense का तो then half of that offense and that punishment, और अगर minimum नहीं दे रखा तो 1/4 of the maximum. So that is how the sentence gets reduced. So इसी को कहते हैं sentence bargaining. चार्ज में क्या होगा? चार्ज बार्गेनिंग है यूएस में, आप सेंटेंस कम नहीं करोगे, किसी भी छोटे ऑफेंस का चार्ज लगा दोगे, बड़े ऑफेंस की जगह किसी छोटे ऑफेंस का चार्ज लगा दोगे एंड फॉर दैट यू विल बी कन्विक्टेड एंड पनिश्ड. अब प्ली बार्गेनिंग का टॉपिक इज ओवर. एसोसिएटेड थिंग्स हैं, कुछ एसोसिएटेड थिंग्स हैं नेक्स्ट सेक्शंस में, दैट हैज टू बी अंडरस्टैंड इन नेक्स्ट सेक्शंस, इन द रिमेनिंग सेक्शंस, बट अदरवाइज द प्ली बार्गेनिंग का प्रोसेस एंड ऑल दिस इज ओवर. And remember one thing, ये एक बार जजमेंट हो जाए प्ली बार्गेनिंग का, दैट इज फाइनल. यू कैन नॉट गो इन अपील इन दैट एक्सेप्टिंग 226 एक्सेट्रा, अदरवाइज आप अपील में नहीं जा सकते. एक्सेप्टिंग आर्टिकल 226 एक्सेट्रा, ये भी लिखा हुआ देखिए 265G. Before that, let's see 265F. The court shall deliver its judgment after all proceedings. Court shall deliver its judgment. Judgment दे दिया गया 265F में. Court shall deliver its judgment in terms of section 265E in the open court, and the same shall be signed by the presiding officer of the court. और judgment दे दिया गया 265 में in terms of 265E in the open court, और वो साइन भी हो गया प्रिसाइडिंग ऑफिसर के द्वारा इन द ओपन कोर्ट. तो वो जजमेंट हमारा कंप्लीट हो गया जब साइन हो गया उस टाइम. नाउ 265G. द जजमेंट डिलीवर्ड बाय द कोर्ट अंडर सेक्शन 265G. यहाँ पे गलती से G लिख दिया है, इट शुड बी F, क्योंकि जजमेंट तो यही हो गया था और जैसे साइन हुआ फाइनल हो गया था. द जजमेंट डिलीवर्ड बाय द कोर्ट अंडर सेक्शन 265F shall be final and no appeal except the special leave petition under Article 136 and writ petition under Article 226 and 227 of the Constitution, Indian Constitution, shall lie in any court against such judgment. क्योंकि आपने compromise करके करवाया, so once you have entered into the compromise and you have judgment, then that judgment is final. जो भी आपको sentence मिला, that should be acceptable to you. You could not go in appeal against that. अब रेड पिटीशन फाइल कर दो आप हाई कोर्ट में या सीधा स्पेशल लिव पिटीशन फाइल कर दो सुप्रीम कोर्ट में, दैट इज अलाउड. बट अदरवाइज नॉर्मली दैट इज नॉर्मल अपील इज नॉट अलाउड अगेंस्ट दैट जजमेंट. अब 265H में ये लिखा हुआ है कि जिस कोर्ट से प्ली बार्गेनिंग हो रहा है, दैट कोर्ट ऑल्सो हैव पावर टू गिव बेल बाउंड्स एक्सेट्रा. दैट कोर्ट ऑल्सो हैव पावर टू गिव बेल एक्सेट्रा. उसी कोर्ट से आप बेल भी ले सकते हो जिसमें प्ली बार्गेनिंग हो रहा है. So that is logical. Plea bargaining जो accused कर रहा है, he is also having the right to apply for bail. He can apply for the bail in the same court. So a court shall have, for the purpose of discharging its function under this chapter, all the powers vested in respect of bail, trial of offence, and other matters relating to the disposal of a case in such court under this code. अब क्लॉज I में ये लिखा हुआ है कि जजमेंट आया, जजमेंट से पहले आप कस्टडी में थे, तो जितने भी दिन आप कस्टडी में थे दैट डेज वुड बी एडजस्टेड. वो हम सेक्शन 428 में भी पढ़ चुके हैं. इन सेक्शन 428 देयर इज ए प्रोविजन दैट ड्यूरिंग the trial inquiry etc, if you are being in custody, then when you get the sentence, out of that sentence the period you have undergone into the custody should be deducted, adjusted. So the provisions of section 428 apply for setting off the period of detention undergone by the accused against the sentence of imprisonment imposed under this chapter in the same manner as they apply in respect of the imprisonment under other provisions of this code. Now read the J. The provisions of this chapter shall have effect notwithstanding anything inconsistent therewith contained in any other provisions of this code, and nothing in such other provisions shall be construed to constrain the meaning of any provision of this chapter. तो एक तरह से इन्होंने overriding position दे दिया. If any provisions in any of the provision in the plea bargaining comes with the conflict of the any other provisions in the CRPC, then the provisions of plea bargaining will prevail. And in 265 they are saying that plea bargaining के process में, please concentrate, accused ने plea bargaining के process में, if the accused has made some statements in the process of plea bargaining, then that statements cannot be used against the accused later on. जो Indian Evidence Act section 23 है, section 23 of the Indian Evidence Act, no prejudice clause. If I am negotiating with you in that process, I admit my guilt, and tomorrow the negotiations fail, then can he use my admission of guilt against me in trial? The answer is no. The same thing is provided here. Notwithstanding anything contained in any law for the time being in force, the statements or facts stated by an accused in an application for plea bargaining filed under section 265B shall not be used for any other purpose except for the purpose of this chapter. Means whatever statements you have made whatever admissions you have made, all that can be used only for the plea bargaining and they cannot be used for any other purpose. उसको उसके खिलाफ एविडेंस में आप यूज नहीं कर सकते. सो दैट इज क्वाइट लॉजिकल. इसका भी स्प्रिट वही है जो सेक्शन 23 का एविडेंस एक्ट में, वहाँ पे भी यही कहता है. मीन्स आपने नो प्रेजुडिस क्लाउज लगा दिया, अगर कह दिया दैट इज नॉट माई प्रेजुडिस, तो आप जो एडमिशंस करते हो दैट एडमिशन कैन नॉट बी यूज्ड अगेंस्ट यू एट द ट्रायल. प्ली बार्गेनिंग के प्रोसेस में यू आर entering into the negotiations. In negotiations you may have to say sorry to the victim. Accused को अगर कहना पड़ जाए कि सॉरी टू विक्टिम कंडीशन रख दे कि जब तक ये सॉरी नहीं बोलेगा मैं नहीं करूँगा प्ली बार्गेनिंग. विक्टिम बोलने लगे कि जब तक तुम मानोगे नहीं तुमने गलती किया मैं प्ली बार्गेनिंग नहीं करूँगा. आपने कहा ठीक है मान लेता हूँ, मुझसे गलती हो गई, मैंने ये ऑफेंस किया तुम्हारे खिलाफ, अब मुझे माफ़ कर दो. और विक्टिम ने ऑडियो रिकॉर्डिंग कर लिया उसका या वीडियो रिकॉर्डिंग कर लिया उसका, और नेगोशिएशन कंप्लीट नहीं हो पाई, पहुंची नहीं सेटिस्फेक्शन तक, और ट्रायल चालू हो गई. और ट्रायल में वो जो आपका स्टेटमेंट है, स्टेटमेंट रिकॉर्ड किया एडमिशन के फॉर्म में, वो यूज़ करना चाह रहा है. कैन दैट बी अलाउड टू बी यूज्ड? द आंसर इज नो. सो इन 265L next section it is said that the plea bargaining would not apply on juvenile, will not apply on juvenile or the Juvenile Justice Act. Nothing in this chapter shall apply to any juvenile or child as defined in Clause K of Section 2 of the Juvenile Justice, Care and Protection Children Act 2000. So that's over with this topic. इसमें कुछ ज़्यादा नहीं है, ढंग से रिवाइज करना, समराइज करना. जो कुछ डिस्क्रिपेंसीज थी वो मैंने बता ही दिया आपको. अदरवाइज देयर इज नॉट मच इन दिस. इन द इंटरव्यू बोर्ड दे ऑफन आस्क क्वेश्चन फ्रॉम द प्ली बार्गेनिंग. सो डाउट वाला एरिया जो पोर्शन है वो बता दिया आपको. द ओनली थिंग इज रिमेन टू रिवाइज एंड समराइज. और जो डिस्क्रिपेंसी वाला एरिया था इन्फॉर्मेशन केस ऑल दैट, वो हमने डिस्कस कर ही लिया है, पर्पज हमने डिस्कस कर लिया है. सो दैट्स इट फॉर दिस टॉपिक. एक पॉइंट और बता देता हूँ, व्हाट इज इन कैमरा एंड व्हाट इज ओपन कोर्ट. जैसे जज साहब है, अदर पार्टीज हैं, और भी लोग बैठे हैं, दैट इज ओपन कोर्ट. पार्टीज हैं, वकील साहब हैं, अदर केस की पार्टीज हैं, दैट इज ओपन कोर्ट. एंड सपोज द जज साहब आस्क्ड टू गो आउटसाइड एक्सेप्ट द कंसर्न पर्सन विद द केस, the general public is not allowed, that is in camera proceedings. Accused is allowed, lawyer is allowed, victim is allowed, family members may be allowed, but the general public is not allowed. Means those who are not concerned with that case, those persons are not allowed. That is what called in camera proceedings. So that's it for today. Thank you for watching this lecture.